But let's talk briefly. There was a case about vaping, and the FDA, and correct me if I'm wrong in the summary, the FDA, it took a long time to basically, it has responsibility for regulating tobacco and tobacco delivery mechanisms. It took a long time to do it, and by the time they did it, a lot of these products were already on the market. So they're now going back and saying, we've determined that fruity and sweet tasting tobacco products are not, on balance, are detrimental to public health, because while the ones that taste like tobacco, you could argue are a way of getting smokers to get off their cigarettes, the ones that taste like, banana splits or strawberries are really to get new smokers and new nicotine addicts into essentially the market. And so they started to ban those. Obviously the sellers of this are like, wait a second, we want to continue to make our profits based upon the societal expense of getting more people addicted to this stuff. And also maybe, who knows what other chemicals are in there and what it's doing to people's bodies. We won't know for another 25 years probably. But is that basically the case that we're looking at?
Yeah. So, let's take a further step back. So recreational use of tobacco has probably been around for thousands of years. It predates the U.S. Republic. Congress did not pass a law allowing the FDA to regulate tobacco until 2009. And so, by that point, tobacco products of all kinds were everywhere. Philip Morris is an enormous company. The Congress decided in 2009 that we were finally going to give the FDA the ability to do something to try to mitigate the health effects of this drug that has been around for a really, 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 really long time. And then the FDA didn't decide until 2016 that it realized, oh God, there's this new technology, vaping. It's causing all kinds of problems too. So we want to make sure that we regulate this in a sensible way. What the 2009 law says is it says that whenever a new tobacco product emerges of any kind, in this case it's vaping, but it would be any new product, the FDA is required to ban it. And the statute's actually really clear. It does not say you may ban it. It says you shall ban it, unless you can show that the product will cause more existing smokers to shift to less dangerous activity without also creating a bunch of new users of nicotine. So that's what the statute says. And the way that the FDA has interpreted that, which I think is very, very sensible, is they have said that, okay, when it comes to vapes, if you want to make a flavorless vape, we'll probably allow that. If you want to allow a vape that tastes like cigarettes, we'll allow that too. And the reason why is that vaping, while not safe, is believed to be safer than smoking. So if you can take people who are already smokers and you get them to switch to a vape, you have made the world better. You have made these people healthier because they're now using a less dangerous product. But the FDA has also said that if you make a vape that tastes like cherries, or that tastes like cotton candy, or that tastes like any kind of sweet flavors that are attractive to kids, that vape is illegal. And the reason why is because that product is not just going to be used by smokers who want to switch to something less dangerous. It is also going to be used by new vapors, by teenagers who think it's cool to have their milk and cookies flavored vape that they can suck on, and now they're addicted to nicotine.
Oh, believe me, I've had a middle school child already. I know.
Yeah.
Okay, so this case is going to come down to that argument, I guess, as to whether, primarily that's where it's going to fall. But I'm curious in particular, and this may not be at play in this case, but we talked probably over the course of the past 10 years, many times about the Chevron doctrine, which was a case where the Supreme Court found, and I believe it was in the mid-'80s, that executive agencies have a certain amount of latitude to determine how to essentially execute the law that has been passed by Congress, so that this law is the spirit of the law is maximized. And the irony was, it was Gorsuch's mom who was the head of the EPA when this case was brought, and it was people who wanted the EPA to do more than they were doing in terms of like environmental issues, and people who were arguing that they're not following the law. And the court at that time said, we're going to defer to the EPA.
Yeah.
And so when liberals, for lack of a better term, got in a position where they were in control of the EPA got more aggressive, because liberals tend to want to protect the environment more at the cost of corporations. And this has been chipped away at and challenged until it was basically overturned, so that conservatives can say, no, there has to be something more specific. You need to take that sort of like ability to execute largely out of the hands of the EPA, or at the very least narrowed in terms of what their mandate is. So now that's where we are, and we're back to where we were in the mid 80s, essentially, in terms of like, so how is that going to impact like the Trump agenda, et cetera, et cetera? Yeah. Like, are we going to see a lot of like lawsuits brought by the left or people who are concerned with the administrative state not doing as much as they're supposed to?
Well, so the broader context here is that Congress passes all kinds of laws that like announce some sort of broad policy, but doesn't like provide an itemized list of here's all the ways that this statute will be executed, including when like new technology emerges that we've never heard of before, when new events arise that we couldn't possibly anticipate. And the question is, when you have a law that is ambiguous or that is being applied to a new situation, who should have the final word on how that law functions? And for many, many, many years, this is what Chevron said. The general rule is we want to defer to federal agencies. You know, we want to defer to the EPA on environmental matters. We want to defer to the FDA on questions about drug regulation. We want to defer to the Labor Department on questions about the workplace. And the reason why is because the Labor Department knows a whole lot. Well, there's two reasons why. One is that the Labor Department knows a whole lot about the workplace and the courts don't. And so if you take that power away from the Labor Department, you're likely to get worse decisions. But the other reason why is that we want to live in a democracy. And so like the issue in Chevron was that you had Gorsuch's mom, who was a conservative Republican, who was making decisions about like power plant regulation that some liberals didn't like. And I think what the Supreme Court appropriately said in the Chevron case is, look, we had an election. Ronald Reagan won. And like that has consequences. And so for the 4 to 8 years that Ronald Reagan gets to be president, he gets to, he and his appointees get to make these decisions. The flip side of that being when you have Barack Obama or Joe Biden in the White House, the same rules should apply.
And within a certain latitude, right? I mean, if Congress says we want there to be healthy skies, healthy air, if an agency finds that like actually, healthy is X number of milligrams of mercury in the air versus, Y number of milligrams of mercury in the air, if there's scientific backing for that, right? Like, I mean, that's the idea.
Yeah, like agencies have to comply with the statute. So like, an agency can't do something that the law doesn't allow it to do. But like, there are times when the law is ambiguous. There are times when the law just a new situation arises.
Right.
And the question is, should I be able to file a lawsuit and get the courts to cancel this decision the agency made that Congress has said the agency gets to make because I don't like the administration that made that decision? And Chevron essentially said the answer to that is no. I think that was correct. I like democracy, even if it hasn't performed very well in the month of November. But
arguably, there's a lot of other months too. But
at this
for another time. For another time.
Anyway, another time. But the broader context here is like when Chevron was handed down, Ronald Reagan was president, Republicans were ascendant, they were winning elections by landslides. And so Republicans loved the idea that power would be given to the president and his administration because they thought that the president would be their guy. And the minute the Obama coalition started being successful, and it looked like you were going to have, Democrats making a lot of consequential decisions at the same time that Republicans had a majority and then a supermajority on the Supreme Court, organizations like the Federalist Society started agitating, started trying to transfer more and more power away from the executive branch to the judiciary. And the reason why is because Republicans have a lock on the judiciary right now. So, why would they want power some of the time when they can have power all of the time? So what does it have to do with the FDA case? Well, the FDA case, I think this case is going to be fine. The statute in this case is really, really clear. FDA didn't do anything wrong. There were several Republican justices, Justice Kavanaugh, Justice Barrett, even Gorsuch at one point signaled that he didn't really think FDA. I think this case is going to be fine. But there was this lower court judge, Andy Oldham, on the Fifth Circuit. And if you know anything about the politics of the court,
we all talk about the Fifth Circuit. That's the one in Texas and Louisiana and is it Oklahoma? And this is where everybody goes to essentially get the craziest right-wing rulings.
Yeah, and if you read Oldham's opinion, Oldham's one of the craziest judges on this crazy court. It is just full of this anti-agency, he has this angry line about the bureaucrats and our fourth branch of government. He's trying to ride this anti-agency anti-agency sentiment within the Supreme Court to say that Andy Oldham, should get to decide what our policy is regarding vapes rather than the FDA. Now, I don't think the Supreme Court's going to go for that. I mean, the first Trump, most of these regulations of vaping started under the first Trump administration. I don't know what we're going to get in the second Trump administration, but at least until very recently, there was a pretty broad bipartisan consensus that we don't want middle schoolers using nicotine. And so, I think that consensus probably still lives on the Supreme Court. Andy Oldham is an outlier. I think that, John Brett and Amy, or at least Brett and Amy, are probably going to look at this and say, I don't want my kid to be addicted to nicotine, and we'll be fine. But the broader context here is that this question of how much power should be held by the Republican judiciary and how much power should be held by federal agencies, which switch back and forth between both parties, is a very live debate. And Andy Oldham's position on this is that I should have all the power.
Interesting. Well, I guess we're going to we'll have more cases, I guess, where we'll see this. And it'll be lawsuits, I would imagine, brought by people on the left saying the EPA, the FDA, the USDA, the SEC are not adhering to the statutes as Congress wanted them. Ian Millhiser, senior correspondent at Vox. We'll link to your pieces on the Skrmetti case. Thanks so much for your time today. Really appreciate it.
Thanks, Sam.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.